Everyone, please be seated. This is a administrative docket conference, and we'll start the 1:30 calendar with ADKT number 276 in the matter of a study committee to review the Nevada Rules of Civil Procedure. A scintillating discussion, I hope, will occur with regard to NRCP 4D. All right, then.
Well, Chief, if I might.
Sure.
Jay Sauerwein wrote a letter to the court pointing out that there was a hole in the rules, like some of our rules, concerning the effectuation of service process on corporate entities. And the purpose of the amendments to 4D is to correct that problem and hopefully clarify whose service is to be addressed to, depending upon whether it's a in-state corporation, an in-state LLC, a member-member LLC, or a manager-member LLC. And I think our clerk and I have proposed a rule, and we would hope the court would consider it. That's all that needs to be said about that.
Any further discussion on ADKT 276? There being none, I see Judge Gonzalez is in the audience, although it's a little bit like being in a lineup here.
Mr. Sauer.
Another country heard from. Jay, you ready?
Can you hear me down there?
Yes. Sounds like a cell phone. Yeah.
I'll try to be brief. I'm Julian Sauerwein of the Reno law firm of Sauerwein and Sloan. I'm also a member of the executive committee of the business law section of the State Bar of Nevada. The background of the proposed change is that when the business law section in 2005 brought forward with the approval of the Board of Governors what was then SB 338, dealing with, among other things, amendments to NRS 14.020 and 030 relating to service of process on business entities. We noted that the statutes I just mentioned listed the various business entities required to have a resident agent. NRCP 4D only applied to domestic and foreign corporations. Back then, we drafted a proposal to amend the rules so that it would apply to limited liability companies, general and limited partnerships, business trusts, and miscellaneous organizations mentioned in Chapter 81 of the NRS. Somehow that proposed rule change did not get transmitted to the court at the time. The lapse came to our attention this year, and I sent the proposed amendment to Justice Hardesty. On behalf of the business law section, I ask that you adopt the proposed amendment with one addition. In 2007, the legislature adopted the 2001 version of the revised Uniform Limited Partnership Act and created a new to Nevada entity called a Registered Limited Liability Limited Partnership. You'll find that in NRS Chapter 87A. So I ask that to the text of the proposed amendment, you add to Clause 3, of subsection D1, the words, or a registered limited liability limited partnership, immediately after the words, a limited partnership, which appear on the 7th line of that subsection. I brought with me the text of the proposed amendment with that addition, and if it please the court, I could leave it with the representative of the clerk's office who is here today, Brandy Mooneyhan. But with that, I have nothing further unless the court has questions.
Any questions of Mr. Sauerwein?
Mr. Sauerwein, thank you for following up on this subject.
Thank you for considering it.
Very good. All right, Judge Gonzalez, if you want to come forward on ADKT 398.
Thank you. I have some updates to my September 5th report that I'll provide to the court. Can you keep those? Chief Justice Hoffman, Justices of the Supreme Court, thank you very much for inviting me to provide an updated status of the business courts in the 8th Judicial District Court. At this time, Judge Denton and I are working very busy. Our caseload has significantly increased. And because of the rule change that will be going into effect next week, we are hoping that some of the tremendous increase we have seen in some of the cases will decline, because we have now increased the threshold of some types of those cases to $500,000 for the amount in issue under Rule 1.618 of the 8th Judicial District Court rules. Currently, we have 770 cases pending between Judge Denton and I in the business court. I was very lucky today that my business court trial settled on the 4th day of trial through the good offices of another judge who conducted a settlement conference. But we are incredibly busy, both in evidentiary hearings on injunctive relief matters, trial matters, and pre-trial hearing matters that we do on our business court cases. We are also trying to do Rule 16 conferences on almost all of our business court cases to have the parties in at a very early stage of the litigation to try to discuss with them ways that they can reach a quick resolution on their matters and ways that they can keep their litigation costs down by limiting or streamlining discovery issues. Those have been very successful, and we are finding that many of our cases are settling shortly after those conferences or shortly after the preliminary injunction hearings that we conduct on the evidentiary, on the injunctive relief hearings. If you have any questions, I'd be happy to answer them. I know Judge Denton's here as well.
I have questions.
Justice Cherry, how are you?
I'm fine, Judge Gonzalez. Before I left the district court bench, I had talked to you and Judge Denton about case management and about your own schedules. I know that Justice Seda and I ran into this problem when we fell on the grenade for a construction defect. And I was wondering, with the new chief judge here, Judge Ritchie, what's your plans as far as what you and Judge Denton will be handling besides business court?
Currently, Judge Denton has a reduced civil load from what a 50% judge, or from what a 100% judge would have. I have a criminal docket, which doesn't have as much reading associated to it, and then I have a reduced civil load from what a 50-50 judge would have.
Well, I've noticed that there's not a lot of reading in the criminal sections of the 8th Judicial District Court in some of my dissents.
I do read the ones that are on my criminal calendar, though, but there's not as much motion practice in the criminal cases as there are in the civil cases. With that said, Judge Denton and I testified before the subcommittee on Chancery for the legislator. We told them that we needed additional judges in the 8th Judicial District Court, and if we were going to be able to be full-time business court judges, we would have to add a like number to our brethren so that the other civil cases would not continue to suffer. The business plan that's been developed through the good offices of Justice Hardesty and Judge Ritchie with the County Commission and is going to be presented to the legislature, I think will assist us in adding judges to the 8th Judicial District Court. But in order for Judge Denton and I to be able to give up to our other caseloads and strictly focus on business court, we need to increase the number of judges that we have assigned in the 8th Judicial District Court.
Judge Gonzalez, specifically within that, though, in the business court, I guess the key element of the business court is the ability to have the emergency hearings. So the question is whether or not anything has been looked at to facilitate you and Judge Denton your ability to deal with those emergency matters. Because, to be truthful, just the trials as a business court matters. Yes, they require some expertise, but that's not the real issue. The real issue is folks have emergencies or are coming in because one party or the other is accusing the other of looting or controlling, and they want a hearing right now.
And I think that Judge Denton and I both are having the same experience, which we are scheduling those on an emergent basis as we go. If it means we take a break from something else we're doing to schedule that, if it means we're scheduling an evidentiary hearing on a preliminary injunction after the 30 or 45 days worth of discovery so we can consolidate the trial on the merits. That's what we're doing. We're getting the parties in for an early meeting, even if it's on a TRO, and having them come in the next day without officially receiving notice, and then having a discussion with them so everybody has an opportunity to be heard, so that we can then frame the issues and get that emergent. I will tell you, it is putting a greater burden on Judge Denton and I than we would like to have, but the need for additional judges in the 8th Judicial Court is critical across the board.
Okay.
Thank you.
Chief, may I ask a couple questions?
Sure.
Judge Gonzalez, I read an article in the paper this week about a derivative suit had been filed against the Las Vegas Sands. I don't know anything about the merits of it, but the interesting part to me was where the case would be tried and all there. I guess it was assigned to one of the departments, and there was a discussion in the article that perhaps this may be a business court case, and I guess being on the business court planning task force with Chief Justice Rose at the time, and I think Justice Hardesty was involved with it. I'm certainly hopeful that you'll have the time to hear those types of cases, because I think our goal originally was to try and make Nevada like Delaware as much as possible, to have a quick and timely resolution of cases that when it has to be. And I might add too, I heard when I was campaigning this year, and I met with a lot of businesses, that generally very positive reaction on the business courts, but there were some comments made, I think more about Washoe County than Clark County, that the trouble was at the back end. Maybe you get the immediate TRO hearings and all are handled well, but to try and get the case to final resolution and all, it had been problematic in Washoe County because of the caseload and all. So I'm just interested in your comments on that.
Currently, to start with your last comment, we are ranging about 18 months to trial for a business court case. But in order for a case to get into business court, one of the parties has to designate that on their initial pleadings, or one of the judges has to refer it to us. So if the parties do not, on their initial complaint that they file, a derivative suit, indicate that it is a business court requested, it will not go to business court unless someone else identifies that. Judge Denton and I do not have time to go through the dockets of every case that is filed on a regular basis. With respect to trying to be like Delaware, Judge Denton and I would truly like to be like our colleagues in Delaware, but their caseloads are less than $300 cases from each of the chancery judges that they have on the Chancery Court. And while we would love to spend the time that those individuals have to dedicate to Chancery Court, we can't because of the huge need we have here in the 8th Judicial, and it's not fair to our colleagues to just take the business court cases and leave them with the civil portion of the docket that they currently have.
Okay.
Will we be seeing a case management plan from the 8th Judicial District, Judge Ritchie?
Come on up, Art.
Good afternoon. Justice Cherry, Art Ritchie with the 8th. We're currently planning for our allocation of cases for next year. The implementation of the allocation of cases was already pretty much set in stone this fall for the beginning of the year. The executive committee for 2009 had a meeting, and we're in the process of evaluating the case assignments, which include not only the civil and the criminal assignments, but the specialty court assignments. The business court assignments really should be a full-time job. And as Judge Gonzalez said, she's handling criminal matters and civil overflow and the business court matters. So what we're trying to do is we're trying to establish a plan. Our goal is by March or April of this year to be able to have a plan that would address or best address the needs of case management in the civil and criminal division. Right now, if 18 months is the ordinary course of business court, that's about 4 or 5 months longer than what we looked at in the summer. And so the answer to your question is a little complicated by the fact that we have to pay a substantial amount of money, I would say more than $100,000, when we ask CMC to organize the transfer of cases for the new judges in the district, and that was already allocated. And so the transfer to the 4 new judges will take place in January as planned. And what we're looking for is in the first quarter of next year to see whether or not that plan is altered in any way.
I worry about whether this case management would conflict with the 60-day rule for criminal defendants and also the Jury Improvement Commission report, which tried to get the juries in the courtroom more than in the hallway. And I know that when emergency situations come up for Judge Denton and for Judge Gonzalez, I know that they're probably torn between, whether they stop what they're doing, especially if it's a jury trial, especially if it's a criminal jury trial. to handle some of these immediate problems of TROs and business-related commitments. So that's my concern as a Supreme Court justice at this time.
Thank you very much.
When you say ordinary course is 18 months, you're talking about from the filing of the complaint or its referral into the program?
That's the filing of the complaint, and that's been our time to disposition for business court cases over, I'd say, the past couple of years. Many of them are settling at the preliminary injunction stage, which brings that time to disposition number down for those cases that are being tried.
Have you been able to look at stats in terms of percentage of cases that fall out after that preliminary hearing or settlement
The number of
conference?
them that actually resolve at that time.
Yes.
I actually was given the spreadsheet about a half hour ago, and I've not been able to go through the 8 pages to figure out which one settled at that
We will
time.
look forward then to your updating us.
Thank you.
What is the ordinary course complaint to trial for a general civil case?
About 39 months now, and that's too long.
Mr. Chief, if I may, Judge Gonzalez, Judge Denton, and Judge Ritchie, notwithstanding the fact that we're asking some tough questions that have only tough answers, as a not too distant member of your bench, I think it is important in this docket to thank you all, as well as your colleagues, for taking on this extra burden. As Judge Cherry indicated, been there, have happily done that in the past. But it needs to be emphasized that what you are doing is an attempt to take the very scarce resources that you have and spread them best around to serve every person who tries to walk through the doors downstairs. And I think that you should all be commended for that, not just the 3 of you who stand here today, but for your colleagues who attempt to assist you when you need their help in pulling another motion calendar or taking on something else that they need to take from you. And I want the Chief of the 8th to know that, and I want both of you to know that as a court, although I speak only as one member of this court, I thank you both for the hard work that you're doing. And I think an 18-month time to disposition is something to be very proud of.
Thank you.
The one question that I would like to say is that even if we're successful in obtaining judicial resources for 2011, that is 2 years from now. I don't know that we'd be doing our job if we looked ahead 2 years to solving this problem. And so we're actually looking, we're setting priorities. Obviously the business court is a priority. And so we're not necessarily looking to solve all the issues of case management with judges that might come on board in January 2011.
Chief, if I might, Judge Gonzalez, are you and Judge Denton familiar with Judge Adams' letter of November 25th?
Yes.
Do you agree with that approach on the preemptory challenge rule, which in order to reduce the risk of forum shopping between 2 business court judges, that the preempt would cause the business court case to go to the general panoply of judges?
When this administrative docket was originally scheduled, we convened a bench bar meeting in the 8th Judicial District Court with members of the business community, business law community. Mr. Hemanowski was on that committee, and he's present here today. And the rule that you have recently implemented, which is EDCR 1.61, that includes subdivision D on peremptory challenges, was the rule that came out of that committee. Well, I certainly understand the position that Judge Adams is taking. After working with the bench bar committee, the rule we came up with is the one that was recently adopted, which does allow peremptory challenges being reassigned to the other assigned business court judges. We had hoped in that committee that we would be able to add business court judges, so it would not just be Judge Denton and I, so it won't simply be a forum shopping between the 2 of us. We still hope to do that, but at this point we have not been able to break the resources free to assign that 3rd business court judge.
I think they're contemplating in the second a backup, or actually 2 business court judges and a backup. Is that something that you've thought about here?
We already have a backup. Judge Earl is our backup judge, and he currently, I believe, has 3 cases that are assigned to him where either Judge Denton or I have been unable to conduct after peremptory challenges have been filed.
Okay, and then Judge Adams is also doing settlement conferences in some cases for you?
Has done at least one for us that I'm familiar with, and he was able to resolve that case. The parties flew up to him in Reno.
Oh, okay. And then the other thing I was curious to know, I know you're the secretary of the National Business Conference or Business Court Judges Association. What is the time to trial in Delaware or some of the other business courts around the country? My impression was that 18 months, although seemingly long, was actually pretty good in comparison to other states.
It is, and the reason, I don't know what the Delaware number is, because Delaware has a very different jurisdictional
Yeah.
framework than we do. They do not handle any, they only handle equity cases in the Chancery Court, so none of the contract disputes that fall within our jurisdiction go before them. Generally, their cases are resolved at the preliminary injunction stage, and that's when you're seeing the Delaware published opinions. I don't know what their time to disposition is, but after talking to our colleagues that are assigned business dockets, we have a good time to disposition rate. But their experience is similar, that many of those cases resolve at the preliminary injunction stage.
Well, when I was on the co-chaired the committee that set up business court, we were advised that the more important number is the disposition number. And your disposition number is still about the same, isn't it? Time to disposition?
It's about 18 months. That's our time to disposition, not our time to trial number, that's our time to
Okay.
disposition.
All
And
right.
that's taking in the average of those who are resolving at the preliminary injunction stage and the average of those who are going to trial. Of course, many more cases are resolving at the earlier stage than the trial.
Sure. Okay, thanks.
Has the creation of this docket in some way at all created a problem vis-à-vis the 60-day rule in criminal cases, that somehow that the existence of this entity is creating a problem with getting criminal cases tried within the 60 days?
Not in my department. I believe I'm the only department it affects. We've not had a single issue with a criminal trial that was ready to go who was not able to go on the date schedule.
Has there been any instances of a case that was going to proceed under the 60-day rule, a criminal case, that somehow interfered with your work in business court?
The only case that interfered with a business court case was a case that the Ninth Circuit ordered be tried within a certain period of time, and then the U.S. District Court did not issue that order telling us what that period of time was for about 45 additional days. So by the time I got the case back, I had 45 days to try it. So I had to cut short a business court trial by 2 days, and I did that by putting time limits on the amount of time they had to present their evidence.
So in general, the case assignments to you with regard to the split case assignments to you with criminal and the business court, they, at least in terms of your gross numbers, there's been no significant effect one on the other.
I'll tell you quite frankly, I've been very lucky in that very few of my criminal trials have gone for an entire week. So I have been able to spend the Thursdays and Fridays that are on my criminal trial weeks to be doing business court activities like emergency hearings, preliminary injunctions hearings, and I have only had to reschedule one of those, and that was because a business court trial over the Plaza name took longer than we thought it would, and I had to reschedule a business court evidentiary hearing that was scheduled while that case was going on.
So in general, then you're able to manage this docket on the understanding, of course, that it takes 18 months to get the cases to trial.
It does,
I
but
mean, is that a fair statement?
it is, and the way that we manage it is we work through lunch, we come in early, we break our jury trial at 4:30 so that we can have that evidentiary hearing, the emergent hearing that must be conducted, and that's the way we've done it. It's been an additional burden on Judge Denton and I, but we have managed to try and put into practice what we were asked to do, which was to give a priority to those business disputes and pay attention to those and hold their hands to help them through the process while still maintaining the other workload that we have. And it's been quite a challenge for us.
Judge Gonzalez, have you considered, and this will impact another one of our budget lines, so I will preliminarily apologize for this question. Have you considered in a situation where you need, for instance, the case you referenced, the Plaza name case, where you might need a bit more time than you had originally anticipated, have you considered requesting a senior judge to cover other matters in your courtroom?
The business litigants are not in favor after having anecdotal discussions with them.
No, let me make it clear. Senior judge coverage for your other matters so that you and Judge Denton.
I will now make my plea to the court, Justice Seda. On February 17th, I start the Southwest Exchange trial. I have been telling all of the lawyers that the regular cases that are set on those dockets will be affected by that. While I will attempt to get a senior judge, there are no guarantees, and I have obtained 1 or 2 volunteers on the district court who will assist me in the trials that are scheduled. But that trial, even though it has been whittled down from the original 1-year estimate, is still a 4 to 6 month estimate, which is going to be a challenge to conduct. I think Justice Douglas remembers when he conducted a very long trial that it can impact your docket by being in trial for that long. So I'm told that I can have a senior judge for a trial that is less than 2 weeks long if they're available, and if it's a trial that's over 2 weeks, I got to go beg for my colleagues to help me, and that is my intention.
I urge you to make your request.
Chief, if I could ask maybe Judge Denton a question too. Judge, I know Judge Gonzalez has been doing civil, criminal, and business court. I think you're doing civil and business court. Would it assist you, or maybe Judge Gonzalez, that when the case management's plan is done from the 8th Judicial District, and I know you have percentages that you use on case assignments and all, if your caseload was reduced, both in regular civil and perhaps criminal, in order to accommodate more time for business court?
I'm told that we've already done that.
Okay.
To a certain extent. There may be some tweaking we can do, it seems to me, with some cases. For example, medical malpractice cases. I don't know that
I took them off your docket.
we don't have those. I tried one last week, in fact. But the fact is, those kind of cases are
Right.
in firm settings, and unfortunately, when you have a lot of other things, these business cases going on, you got a firm med mal setting, it's hard to.
And we appreciate that because I know we have mandates from the legislature on med mal, and it's hard to please everybody and comply with the law, so we appreciate your efforts. But I just thought in doing the percentages that if that would give both of you some relief, it might be something that would be the future Chief Judge Ritchie and whoever's working on that might consider.
I actually wrote the case management percentage numbers, and both Judge Denton and I had reduced from those of our colleagues who either in his case had 100% civil or in my case 50% civil. The numbers were reduced, but it is still a significant number of cases that need to be handled. And I know that the executive committee is continuing to have those discussions about ways to give us relief, but it is a challenging situation given our other needs.
Right. Chief, I have one more question and I'll be finished. Judge Gonzalez, I don't know if you and Judge Denton saw the letter from Chief Judge Steinheimer of the 2nd Judicial District regarding the dollar limits for business courts.
I did not see Judge Steinheimer's letter, only Judge Adams' letter.
Okay, well, Judge Steinheimer's just came out. I don't know, it was copied to all the Supreme Court, but it just came out December 5th, so I don't know if I gave Justice Hardesty a copy of it, but this is an additional comment. It says, in addition to the comments submitted by Business Court Judge Adams, the district judges asked the jurisdictional limit in the 2nd Judicial District be set at $250,000 instead of the recommended $500,000. Now, we haven't had a chance to, and I don't know if anybody from the 2nd District's here today to comment on that, but I see Mr. Conyers in back. I didn't see him, so perhaps we'll ask him to comment on that instead of you, then like that. But you're okay with the $500,000?
Our number on the $500,000 was developed by our bench bar committee after we had those consultations when this docket first started. So that was the number that was discussed among, I think we had 6 members of the community that were on our rules committee for the bench bar committee. So we established the $500,000, $250,000 may be a workable number, but that was the number that we came up with after the meetings we did.
Okay.
And I would like to say, in some support of Judge Adams' point regarding peremptory challenges, I mean, we've got these new rules going to be implemented soon. I think we ought to hold that in reserve and see how they work, but it's actually a very interesting concept. It could very well be something useful down the road if it turns out under the new rules that we're going to be having a lot of forum shopping and things like that through business court.
Are you going to be monitoring that, Judge Denton, the numbers on the preempts to see what kind of bounce back and forth?
I think it would be a good idea.
Yeah, I think it would be worthwhile to do that.
So far, things have been working well, and there hasn't been all that much forum shopping, at least in my experience, although it's obvious when it arises.
Looking for the letters. Is Judge Adams under the impression that this is going to be a big problem in a second?
Well, it was a problem even before now, and so he perceives it to be one. I think Judge Denton's right. We ought to monitor it, see what the numbers look like, and maybe take a look at it in 6 months.
Anything further from the three of you?
Thank you very much.
With that in mind, any more comment here in Las Vegas on ADKT 398?
Chief, we have someone from this, I guess, address from Washoe. Mr.
Oh, well, yeah,
Justice, you were asking, you open for comment?
yes.
I'd just like to say a couple of things. I'm one of the people who uses a lot of the business court services, and it has made a tremendous improvement in the kind of practice I have. When you have people coming from out of state who are contemplating significant litigation, I assure you they're reassured at the beginning when they hear that there is a business court, because they hope that that means that there are people who have some expertise in the areas that they're particularly interested in. And when we talk about competing with Delaware, of course, having that kind of judicial resource to draw upon has been of critical importance. And I think I would have to say that within the limits that we have to work in, this business court experiment, if I can call it that, has been a great success. It really has made a difference. It's moved cases along faster. It allows us to provide clients some assurance that when they come into court, they don't have to start at the very basic part of explaining what are some very complicated concepts. Because the things we deal with in the business court are some of the most complicated issues presented to a court. So they have that kind of assurance. We have the problem that continues with the lack of resources, the shortage of resources. We don't have enough time among these business court judges for them to give us a written opinion, for example, on the matters that come before them. The significance of that is, as we're trying to develop a body of jurisprudence here in business court to show that this is a working environment, I've got 3 different judges dealing with perhaps the same issues in any given period of time, and we don't have the benefit of being able to see what the others have done. And they don't have the opportunity to provide us that guidance because they don't have the time. As you heard from Judge Gonzalez and Judge Denton, they take on quite a load, in part because they want to be seen as sharing the same burden, I suspect, of the other judges on the bench, and they're all in this together. But it doesn't take account of the fact that these business court cases are such enormous consumers of resources. I mean, the lawyers spend hundreds of hours writing a motion. And they produce, and you've seen the motions that come out and the complicated issues that are presented. It takes a great deal of time to analyze those. And if we had one thing I wish we could do a little differently with what we have, it would be to have enough time for the judges to not only reflect on what's presented to them, but to be able to write the kind of opinions that could be circulated among the different business judges and the business bar so that we could all benefit from building on the expertise we're developing.
What you're suggesting is a case-weighted distribution model.
Yes, precisely that. Thank you for the opportunity to address you.
Thank you. It's interesting. We have received over time mixed signals from the legislature about this project. When the legislature, members of the Judiciary Committee came to Justice Rose and other members of the court, including myself, back in I think it was 2001. One of the things that they were very interested in is to diversify the economy of Nevada. And one of the things that they thought would help diversify the economy was if we became a more business-friendly state, not only from our statutory constructs, but from our judicial constructs. Now, having said that, the court obtained an agreement with the legislature rather than to seek a constitutional amendment that we would create these dockets, which we did do. But every year when we go to the legislature, we get mixed signals about courts for special interests versus the need for courts for other important issues such as dependent children and the like. Those are all those are interests that call upon the resources of the judicial system. So what I think is going to be very important for the future of the business court is that the stakeholders in this make sure they're present at the legislature so that when the discussions occur over this commitment or resources occur, you're ready for it.
Well, I think I attended all but perhaps one of the Joint Committee Chancery Court that Senator Beers had chaired. And I've testified there, and you're quite right, of course. There's a lot of competition for scant resources, and it's going to be very difficult. But if, in fact, the legislature says we want to compete with states like Delaware, and if this court, as I understand, has been behind the concept of trying to provide that kind of service, then we have to look at how we're going to allocate the resources here. And we've got great people here and in Reno, or in Washoe County, working on it with the judges we have, but we've given them an awful tough task with the maintaining both the business court and trying to maintain other calendars at the same time.
And my only point is that there are members of the legislature that are less enthusiastic about this idea than we are.
I appreciate that.
Mr. Hemanowski, I have a question for
Yes,
you.
sir.
How is it, as far as how much trial time are you getting in business court cases, and how much law and motion time are you getting? Because I have concerns about that.
Well, fortunately, if we do the law and motion practice right, we don't do so much trial time. And we've been very fortunate in that. I'll give you an example. I had one very complicated case that involves a great deal of money and international issues and so forth. Judge Gonzalez was able to schedule, I think, 7 or 8 evidentiary days, solid days, of hearings, which went a long way towards resolving the whole case. It's the equivalent of a trial, but it wasn't a trial. It was fought out, in that case, on a motion for contempt, but it could as easily have been analogized to a preliminary injunction hearing. Either way, it's pretty close to dispositive. So, try to answer the question. Most of the practice there, by far, is motion practice.
I'm asking maybe for some help on convincing Judge Denton and Judge Gonzalez to cut down on their other cases to offer you more time, but I need the right answer from you.
Well, the answer is not the question of trial time. The answer is they need more time to deal with the substantive issues which normally come before them in motions. Sometimes it's trials. But a lot of these things, like the big business disputes, when you have, for example, had a case in front of Judge Denton, somebody was trying to enjoin the Harris merger, a $15 billion transaction. This had a lot of attention, and it had a lot of paper. It takes a lot of time to read that, and it's disposed of at the preliminary injunction stage. But they need the time, for me to really benefit from somebody else's case, they need the time to write reasoned opinions that the rest of us can be guided by, that we can use with our clients, and we can use in shaping our own individual situations. And that, to me, I'd like to have a lot more, believe me. But if I had to say one thing in the short term that we could do that would help this process, it would be to give the judges who are in business court the opportunity to try to work their cases at the level the Delaware Chancery Court and the other well-established business courts do. So that when I deal with my clients, I can say, look, here are opinions that have already been written by our judges in related areas, and you can see the kind of reasoning and the expertise they bring to bear. Because oftentimes I'm involved in conferences with lawyers who are saying, where are we going to bring the lawsuit? Is it going to be in this state? It's going to be in another state? Where's the best place for it to be? Where are we? And always the question they want to know is not, believe it or not, it's not, are they going to rule in our favor? Nobody asks anything that crass. They want to know, are we going to have people who will understand the issues? We have people who can grasp and grapple with the kind of stuff we want to present. That's the concern they have. I can answer it anecdotally, but I'd sure like to be able to answer it with a pile of opinions.
Well, and I think this is why your advocacy and other business lawyers' advocacy in front of Senator Beers' subcommittee led to the recommendations they adopted, which was to abandon the adoption of a chancery court and support the existing business court model because of the opportunity there. While we have a short-term crisis, no doubt, the judicial business plan that Judge Ritchie and the 8th Judicial District staff has formulated, I think, presents some great opportunities to add a number of civil judges to the district, which will provide some relief in this area within a couple of years. And I think it'll make a big difference. I hope the bar will get behind that, and I know that Chairman Reed has been a staunch advocate of that plan.
Well, thank you again for the opportunity to address it.
All right, thank you. Any other witnesses in Las Vegas that would like to come forward and discuss the ADK 398?
May it please the court, I'm Howard Conyers. I am the court administrator and clerk for the 2nd Judicial District. Judge Steinheimer regrets that she's not able to be here. She's preparing for some matters tomorrow and asked me to come in her stead. The court should have 2 correspondences, one as noted from Judge Adams in October, and one from Judge Steinheimer as Chief Judge, dated the 5th of December. The reason for the late date on hers is that it was only on the 5th of December that we had our previously scheduled judicial retreat, at which this matter and several others were brought to the attention of the entire bench at one time. So while this is important, and she would not for a moment want you to think she treated it otherwise, she felt the need as Chief Judge to be speaking for the court, not just as a member of the court. And that is the reason for her rather late note to you all. I'd be happy to try to answer any questions.
And essentially, the second wants a reduced dollar jurisdictional amount.
That's correct.
Because of the size of the cases there may not warrant that kind of jurisdictional limit.
That is correct. I apologize for hearing to cut you off.
Any other questions from the court? Thank you very much. Have a good holiday season. Anyone else in Las Vegas wishing to speak?
Oh, I'm sorry. Mr. Conyers, did the district make a decision about how to allocate its business court judges and resources at the retreat? And how has it decided to do that?
It has made the decision to continue, Your Honor, with at least 2 and perhaps as many as 3 business court judges. I don't know that the assignment of who those persons will be has been made, but they did make that decision just to provide for the safety valve, if you will, rather than merely having a single business court judge.
And you heard the discussion we had about preempts and whether they're being used for forum shopping. You have the case management capability to track that, correct?
We do, Your Honor.
And could you do that over the next 6 months?
We will. Okay. Yes, sir.
Yeah. Mr. Conyers, too, following on what Justice Hardesty said, again, you heard my previous comments that I heard anecdotally about Washoe County, that they do a great job, and I assume Judge Adams and whoever else assists in getting early action on these cases, but it's kind of problematic in getting the case to be finally resolved because of the judges' calendars and all. Do you know if that issue is going to be addressed by the district court to maybe try and expedite the final resolution of these cases in Washoe County?
We continue to try to monitor, Your Honor, and we hope to expedite it. Ideally, some help would come from our version of the judicial plan that we're working with Justice Hardesty and the 8th on. But barring that, we continue to try to monitor and try to expedite those things because a quick expedition, expediting in those cases is clearly important. And I know Judge Adams feels that way and has always made that his goal, but we'll continue to do so.
Thank you.
I have one other issue. As a short-term answer to some of the difficulty that the 8th Judicial District is experiencing, I've discussed with Judge Adams and Judge Steinheimer the possibility of assigning some of the Washoe District Court business judges to business cases in the 8th Judicial District. And I would like to ask Judge Gonzalez and Judge Denton to visit with your colleagues in the 2nd and with your bench bar here to see if some relief can be provided. They are obviously talented business court judges. I don't know that their docket is nearly as substantial as yours, certainly not in this area. And they are available and could be available for assignment in some of these cases to relieve some of this pressure. I think we need to be taking a look at this issue from a statewide basis. And so I would ask that the business court judges get together with the bench bar in the 8th and examine that as a possibility.
We'll certainly cooperate any way we can.
I have a question about other complex litigation, aside from the business court matters. What about how Washoe would handle other complex litigation, such as construction defect? Is there talk about that, having a special complex litigation judge or judges?
I have not heard any such talk, Justice Chair. I have not been privy to it.
Anything further?
Nothing for me, Your Honor.
Anything further from any witnesses here in Las Vegas? Going once? All right, in Carson City, anyone wishing to speak on ADKT 398 from Carson City? It appears that there are none. We'll close the hearing on administrative docket item 398 and move to administrative docket item 310 in the matter of NRS 38.258 and short jury trials in the Supreme Court of the Nevada. Possible clarification of NSTR 27. Have anyone here to speak on that? I understand. Mr. Beecroft.
Good afternoon. Chris Beecroft, ADR Commissioner for the 8th Judicial District Court. Chief Justice, I'm not sure how to comment on it. I'm uncertain as to the nature of the confusion regarding the amount of attorney's fees to be awarded as a result of NSTR 27. And I was just seeking some clarification from the court as to that issue.
Justice Gibbons.
Well, I will look back, Mr. Beecroft. It's a good question here, and I think you saw the correspondence from Mr. Jensen, I think previously, and all on suggestions. I think it more went back to that. If there's anything you just want to comment on, the suggestions that go back and forth between them, and I think you were copied on all that correspondence.
Well, right, and I was, Justice, and I guess my only comment was that that was the reasoning I thought that the Supreme Court amended NSTR to permit the parties to stipulate to an amount greater than the $3,000 cap. And I guess I wanted some further clarification. My understanding of 27A, which of course is a case removed from the short trial program and tried at the district court level, my understanding is that there is no cap with respect to the amount of attorney's fees that can be awarded in those types of cases. And so if the Supreme Court is considering perhaps a good cause exception under 27B for cases that are tried through the short trial program, is that something the court is
well, I think, and Justice Hardesty might want to comment, my recollection was we were going back and forth on suggestions from you and from Wes Ayers and from Bob Jensen and all, and we just wanted to have this hearing today if anyone wanted to make any final comments, and then I don't know what the court will consider. I guess seven of us will adjourn and discuss it then, but I just want to give you any final opportunities and anything else you wanted to add or suggest.
Well, I'm wondering, Mr. Beecroft, if you're familiar with the correspondence from Bill Cobb, and as well as the correspondence from Al Panier, which touch on this issue.
I do not recall seeing those.
Okay, I think it would be important for you to be able to see those and to comment on those, because it's actually the correspondence from those lawyers that raised this issue, and the issue came up after the short trial amendments were made.
Okay.
And so it was something that they'd requested that the court visit, and they explain, unfortunately, my files in Carson City, or I'd give you the correspondence and explain the problem, but they were able to identify in specific cases how this problem arises in the manner in which the rule is articulated. Okay. So I think if we could, Chief, I'd like to get the correspondence to Mr. Beecroft. I'd already sent it to Mr. Ayers. He actually agreed with the problem, but I'd like Mr. Beecroft to see it, and maybe he could file something in 30 days or so as to your reaction to their concerns.
Justice Hardesty, in terms of the 30-day limitation, I guess I would ask for a little more time, because my question is whether or not this has been looked at by the bench bar, civil bench bar.
Nelson, do you want to verify?
And if they have any input as to this.
Sure.
Justice Maltman, Supreme Court. I'm Nelson Siegel. I'm here as Nelson Siegel, but I also have a hat that I can't wear today because I'm not officially here. But I am the chairman of the State Bar's ADR section. Something, a section that's existed for many years. We're trying to get more active and involved in what goes on in the court, both down here in the 8th District. The second, we have some people in the second that are working on things, and as well as with this court. And I did appear in February when some short trial rules issues were raised and gave my thoughts what they were worth. I'm not real sure what the issue is today. I haven't seen any of these letters. I don't really know what's involved. But I did get a couple of phone calls from short trial judges talking to me about egregious cases that they sat on and how they had to grit their teeth when they felt that they could give no more than $3,000, whether it was appropriate or inappropriate. I know the defense bar is very much in the position that this program exists because there's a $3,000 cap. However, there's an issue, I think, that whether there might be reasonable exceptions. In February, we talked about an exception for late exemptions, that the commissioner could do a late exemption under appropriate circumstances, extraordinary circumstances. And I have to question whether or not this existing rule, the $3,000 rule, might not be something that we should be revisited, whether it's to increase the number from the 3,000 to a higher number, or to have some type of provision that would provide for an increase in the cap. My concern is I want to appear in front of you with my credentials. I want to hear either on behalf of the ADR section. If I have a committee meeting and the ADR section approves it, I can appear here as the chairman of the ADR section and tell you what the ADR section believes in. If I have time to have the board of governors review our determination and they anoint it, I can come here and tell you what the state bar believes. However, I do plan on having a meeting of the ADR section in January. I haven't scheduled it yet, but hopefully the second or third week of January. I think the board of governors meets again in February, but I'm not certain. And I would love the opportunity, if the court has these issues, to have the opportunity to review the issues that have been suggested, have a committee meeting in the ADR section, which includes both plaintiff and defense bar, as well as come up with a position for that committee and take it to the state bar and get their position and come back to you in more like 90 days or 120 days as opposed to the 30 days that you suggested for Commissioner Baker.
No offense to the state bar, but the ADR section and the local bench bar committees, I guess, would be more helpful from my standpoint because those are the parties who are utilizing it on a hands-on basis.
Well, I think you make a great suggestion, and the tenor of the correspondence, as I recall it from Mr. Pawnee and from Mr. Cobb, is exactly what you're talking about. Perhaps, Chief, if we could move this out to May for the court to reconsider and ask yourself and Mr. Beecroft and any other interested party to submit some comments to the court, and we can continue the public hearing perhaps till May.
I can assure you that the ADR section would have a definite position by that time, whether we have the state bar or not. But the ADR section, which would include practitioners on both sides, would definitely have a position of what they thought might be appropriate for amendments to the rules, if any.
Is there a consensus of the court on this?
Fine with me.
Yes.
Great.
I don't get to sit here very often, but in district court, we used to always say, well, that'll be the order.
Thank you.
Thank you very much.
Okay. And Chief, I know.
They still say that in district court.
Chief, I know Justice-elect Pickering's here, and we glad she's listening to this as a primer, so it sounds like we'll have some issues she'll be able to weigh in on as well.
And as the candle flickers on my term as Chief Justice, Justice Hardesty, you're by order to take care of that.
Right. Get right on that.
405, the matter of the temporary suspension of the collection of jury demand fees required by NRCP 38. Should have somebody from Clark County Court Administration, I would imagine, on that issue.
Supreme Court, Steve Gerson, the Assistant Clerk of the Court for the 8th Judicial District Court and the Clark County Courts. I have Jillian Prieto with me, and this is the suspension of jury fees comes from the transition of the Clerk of the Court to the 8th Judicial District Court in last year in January. Essentially, when we took over the Clerk of the Court, we had a trust account reconciliation project that we entered into early on in the transition. What we recognized immediately is that in order for us to complete the reconciliation, we had these jury fee demands that were outstanding and still being collected at the same time. In order for us to accomplish what we thought we needed to accomplish, we asked the Supreme Court to support us in an effort to give us a temporary suspension of the jury fees so that we could go into the accounts, return all the jury fees to the parties that have given us the jury fees, not collect the jury fees from new parties filing for trial. And here we are a couple years later with an account that's very close to reconciled. And we had recommended in several of our reports to you that a discretionary ability to collect jury demand fees is beneficial, especially for a large urban court where you have a lot of transactions taking place.
Any comments from the court? We've visited this several times.
Yeah, I think just briefly, Mr. Gerson, I know we've gotten comments from other districts throughout the state. We had a letter here of November 26th from the First Judicial District Court, Judge Maddox and Judge Russell. And a lot of the other courts don't want to do this, what the 8th's done. I guess our concern is this is a provision in the NRCP, so we're hoping to do it statewide since the rule affects everybody and all like that. But is it something that we might have to address by a local rule as opposed to the NRCP or that's kind of the dilemma we have right now in dealing with it. So if you or Ms. Prieto wanted to address that.
Looking at the proposed rule attached, it looks like us having our own rule would be beneficial for other smaller rural courts to collect those if they so choose. But with our accounting and what we're finding, as you've read the reports, I'm sure several times, 2 to 3% of these jury demand fees actually go to trial. So for us, it's helping us balance. The only issue we are finding is a little bit of commentary from the legal community, the bar, wondering if this actually applies to the short trial program. In what we originally presented to you, asked for the suspension to apply to the jury trials in this court. And what's happened is the bar is saying, well, it's been suspended in the Clark County Courts and the 8th Judicial District Court. Why are we still paying over in the short trial program? So I think that with the order that this court has issued on November 6th, giving us sort of that discretion to craft a rule, we could probably address all of those concerns, and I think everybody will have what they want if we want to keep those fees, keep collecting those fees under the short trial program, and if we want to suspend them here, I think that you guys, the justices gave us the opportunity to craft a rule where we can address all those issues and everybody can get what they want at the end.
Is there really a reason to continue to collect the fees for short trials in the 8th District?
I'm not sure.
Do you have any numbers? You indicated 2 or 3% of the jury trials in the district court actually proceed to a jury trial, and the whole number that are filed. What about the short trial program? Do you have any statistics or any numbers? I would imagine they would be higher. And there might be some more utility to collecting those fees up front.
I actually do have those numbers. Unfortunately, I didn't know that we would be questioned on that. We're in the midst of preparing an updated supplemental report, as this court has requested, to be submitted, and all those figures have been pulled. I don't know if the crux of collecting that is to keep the litigants in the short trial programs to assist the 8th Judicial District Court with their calendars. And from speaking to Commissioner Beecroft, that was implemented so would keep them there and they wouldn't just all flood the court. I do have those figures. I'd be more than happy to provide those at the time of submitting our supplemental report to the court on an update on this.
Has everything been dispersed from the trust account at this point or escheated?
Yes. I think it was in the beginning of this year, we sent over a little bit over $1 million in unclaimed funds after we went through the proper notification, and finding the proper party. It's unbelievable how many people don't want millions of dollars, but it happens. So once we did the proper notification, we took all the records. We did actually issue those funds to the state. But what we have now, we now have a more organized system where once something is collected or interpled, the clock starts ticking at that point, and we are notifying them on an annual basis to make sure that everything is issued immediately.
And that raises the question that is a nasty refrain from me every time this matter is on our docket. You talk about keeping track of things, and neither of you were here the last time I asked this question, so I apologize. But one of the reasons that the initial request for suspension was based upon had to do with the fact that all of this had been hand entries over decades, as I understand it. And so I asked, according to the notes on the face of my file, the very first time that y'all appeared, here we are in the, 2000-somethings, and you can do just about anything with a computer, but it was unbelievable to me that we were dealing with these millions of dollars, and yet we were still keeping track of these millions of dollars on what I understood to be 3x5 cards. So I've asked this question every time y'all have appeared, every time this appears on our docket, and I keep getting the same answer about whether or not your computer system is now updated and able to handle these type of transactions. And I keep being told that last time, new case management system, parenthetically, Odyssey, was going to be up and running, quote, soon. Anybody want to give me something a bit more definitive on that?
Yes, you'll be happy to know that we no longer have a 3x5 card to manage.
I'd be happier to know that you have a case management system that actually handles this, so that when we ask these questions about short trial, etc., you, and I know, Mr. Gerson, from past experience working with you, are able to produce not only an immediate report, but a very reader, user-friendly report so that we can understand these issues. And I'm hoping that that's what you're going to tell me.
In this case, that's correct. We've found a way in the Blackstone case management system to enter the 3x5 cards so that we can actually do a reconciliation. We actually have an outstanding checklist that we do by hand, but we actually enter the 3x5 cards and the outstanding civil issues. We've entered them all into the system as a part of our reconciliation effort.
Into Blackstone?
Yes, we've actually automated all of the trust accounts into Blackstone. Now, it cannot process checks properly without an outstanding checklist. So we still do that part by hand, but we don't use any 3x5 cards when we do any of our civil activities.
Where are we on Odyssey?
The last projection was the last week of April, go live for the civil.
That's funny. The last projection that I have noted here, go live, was March. We just keep moving it up?
Yes, there was a delay in go live for Odyssey.
And again, my most sincere apologies to you two. You weren't the ones that should have fielded this question, but I think it's time.
We agree.
Yes, definitely.
Anything else on this matter? Anything on this matter?
Well, I guess just one final question. Does the order of November 6th then provide you with the flexibility that your district needs to deal with the suspension of the rule?
I believe it does, reading through it, that we will meet as a committee with the Rules Committee, Judge Vega, and we will sit down and compile something and pass that through all the judges and get something moving. But definitely it does answer, and it does give us the flexibility where if we think that it is still needed in the short trial program or not, we can proceed in that way. So
You'll let us know with the filing of the proposed local rule.
definitely. I'll have all that attached to the supplemental report that you've requested.
Anybody else on 405 in Las Vegas? Anyone on 405 in Carson City? Anyone on 405 in Carson City? Very well. That ends the docket items on the 1:30 agenda. However, my understanding is that Judge Gonzalez has some comments to make about the 3 o'clock agenda, the malpractice rules.
That's okay. My trial settled this morning, so I'm here for the 3 o'clock agenda. Thank you.
Very good. Court